The second part of the lectures on enforcement, we're going to look at the other two options that are available to the FDA. Uh, we looked previously at warning letters, and we also looked at seizures. We're going to now look at injunctions, and then we're going to spend a little more time looking at recalls. Uh, we certainly see a lot more product being recalled than we see injunctions being taken against a company or an individual for product that is in violation of the Federal Food and Drug Cosmetic Act and other laws and regulations that have been passed since then. So let's begin to look at injunctions. The injunction requires the cause of the problem to be corrected before the product is shipped. In other words, the product is still being held by the manufacturer. It may be within the manufacturing plant itself. It may also be within a warehouse or a distribution center. And unlike seizures, which are issued against the actual product, injunctions are issued against a company or an individual. And the function of injunction is to prevent product that's in violation of the Federal Food and Drug Cosmetic Act from actually entering the marketplace. And like as we talked about with HACCP, injunction actions requires the corrective action be taken with that product that is being held under an injunction. And it's issued because a product is claimed to be adulterated or misbranded. Examples would be the product has been stored under insanitary conditions. Perhaps it's stored in your processing facility or warehouse or distribution center where there happens to be an infestation of pests such as rodents, and they find an inspection that there is urine and feces from rodents on the product. Even if it's in the packaging of that product and doesn't come in direct contact with that product, then that product is being held under insanitary conditions. The product doesn't comply with the labeling requirements. Perhaps there's some issues with the nutrient label, nutrient facts, ingredient statement. The plant isn't operating under current good manufacturing practices, and the product requires but doesn't have FDA approval. We might see this happen certainly with dietary supplements, perhaps more than other products, for the simple reason it might contain a new dietary ingredient which hasn't been certainly gone through the FDA approval. And how might one avoid an injunction being issued against your particular company or against that individual? One is if you've received one or more warning letters and you make the corrections that have been stated in those warning letters, then that may be one way to avoid an injunction. If your product has been seized and is being held, if you correct the problems that caused that product to be actually seized, that may be another way to avoid an injunction. If you make a deliberate effort to comply with the law, certainly may prevent an injunction from being issued against your company or an individual. And then being alert to responsive to actions that indicate there has been inadvertent or unintentional violation that may have been pointed out by the inspector. You, as the manager of the company, may not have been aware of this, but if it's pointed out certainly by the inspector during the inspection and you become aware of that and correct that, that's another way that an injunction might not be issued. So what's the injunction process? It's similar to the seizure process, actually. It's issued by a federal district court, and it's going to be issued in response to a recommendation by first the district office. Then that goes on to headquarters. They review the reason for the injunction, for whether injunction may be issued. And then it goes to the FDA Office of General Counsel, where lawyers would look over the reason for issuing the injunction. It would go to the U.S. Justice Department, and then on to the Assistant U.S. Attorney in District Court. So again, this requires action of the court. It can't be done by the FDA. Warning letters can, seizures and injunctions cannot. They will offer you a consent decree at the time of the injunction, and this is offered to defendants when the actual injunction is filed, and it's an opportunity to actually avoid an injunction trial. And in order to do this, any deficiencies that are pointed out must be corrected. In the case of product held on unsanitary conditions, bringing in a pest control officer to address that issue, maybe repackage the product after it's been sanitized, the can top say. This is one way. Products that's in violation must be destroyed. The FDA is paid for the filing costs, so you have to pay the filing costs to the FDA. And the FDA may impose additional requirements as it sees fit. In some instances, it requires immediate action, and that's to safeguard the welfare of you as the consumer. And in these instances, the FDA may actually request a preliminary injunction or a temporary restraining order. If you want to get the product held the quickest, a temporary restraining order is the fastest way to actually remove that product from the marketplace or prevent it from entering the marketplace. A preliminary injunction, you actually have to have a court hearing, and it will take a little longer actually to get a preliminary injunction than to get a temporary restraining order. So if that product is one where there's maybe concerns, say for something like Salmonella or E. coli 157 being the issue, perhaps even the fact that it has an unlabeled allergen such as peanuts, they may get a temporary restraining order just to make sure that that product doesn't get out to the consumer. Violation of the injunction or the consent decree can lead to contempt of court filings, which could lead certainly to prison time as well as fines. So what are a couple examples of injunctions? As I say, we don't see very many. There was one in June of 2017 against a company from New York called Smokehouse of New York. And this particular company had not addressed issues that certainly had been pointed out to them several times, and they had a product that was still in violation. And they had warning letters were issued to them in 2011, and there was product that had been recalled both in 2013 and 2017. So the company had never addressed the issues that had been pointed out with their smoke product, and as a result, an injunction was issued against the actual company. Another one, one that's occurred against several companies actually, as of August of 2018, deals with dietary supplements, and several companies that were selling sexual enhancement products had injunctions against them because they were selling products that had unapproved drugs. And remember, with dietary supplements, one cannot have drugs, and they can't make claims, the same claims that it can treat a certain disease as one can make with drugs. So those are the only products, remember, that can make those claims. So these products, companies were issued injunctions by the FDA for that reason. So let's look at recalls. A situation that leads to a recall may be discovered either by the company or by the FDA. And a recall is removal of that product from warehouses, distribution centers, retail sales outlets, and even down to the home. And the type of recall and the reason for the recall will determine how far down the chain that recall needs to go. If you certainly look at the media, print media sometimes, or even audio-video media, we will see that there have been certainly recalls of product with certain lot numbers on them for reasons that may be related certainly to food safety. The major purpose certainly of a recall is to protect you as a consumer. and it wants to protect you against potential health hazards, severe economic deception, or other major violations of the Federal Food and Drug Cosmetic Act. Certainly potential health hazards would be things such as a product that has undeclared peanuts associated with them, product that may have the possibility of containing some of the foodborne pathogens, certainly, such as E. coli, Salmonella, Listeria, three good examples. Severe economic deception would be things such as taking honey and diluting it with high fructose corn syrup. That certainly is severe economic deception to you as a consumer. Taking whole milk, diluting that with water, again, would be economic deception as well. Taking maple syrup and adding high fructose corn syrup to dilute it, again, that's another example of severe economic deception. And recall certainly is a serious action, and it must be carefully planned, executed, and monitored. All companies should have a recall plan in place so that and they have practiced it so that they know what they're going to do if there comes a time when they need to actually take product out of the marketplace. So it cannot be initiated when the recall is required. So you need advanced planning and a thorough understanding of the requirements for a recall, the recommended procedures, and the implications of the recall. And there are two instances when that recall level must be down to the consumer level. There may be others, but in this instances, in other words, product has to be recovered from the consumer. And this is in the case of underprocessed or mishandled low-acid canned foods, and also with acidified foods. So these are the two instances where that recall has to be down to the consumer level. There are three types of product removals. The stock recovery, and this occurs when that product is still under control of the manufacturer. It may be being held in a warehouse. A market withdrawal, the product is of lower quality than desired, and it's an insignificant violation or even no violation at all. A company may have quality standards that they have set for their product, and a lot or two of that product may not meet the quality requirements that they've set for it, and this would be considered to be a market withdrawal. This would not be certainly an issue where the consumer would need to be worried about any potential hazard to them. And then a recall. This product certainly represents a potential hazard. The first step in a recall is to determine the type of removal. Certainly, as I mentioned before, you as a consumer may need to be alerted to potential danger, and we see this quite often, probably almost on at least every couple of weeks, this product that's being recalled for one reason or another. Oftentimes, certainly, those recalls go down to the consumer level. You can either throw out the product if you have it, or you can return it to the place where you purchased it. The market withdrawal, in the instance of quality defects, don't go down below the retail or outlet level. So that product is only going to be recovered at this level. If you have some as a consumer, they're going to probably let you know. The product's not going to hurt you if you eat it, even though it's of certainly lower quality. And these recalls are the most effective way to remove product from the marketplace. There are three classes of recalls. Class 1 recall would be an instance where that product would be of serious health consequence or even death to consumers. The instance of undeclared sulfites above 20 parts per million would be an example of that. At least one, the presence of Listeria monocytogenes, which has zero tolerance in the product, certainly would be a Class 1 recall. In a Class 2 recall, the product may cause temporary or medically reversible health consequences. Examples of this may ultimately be some of the food allergens where the results of that allergy a food allergy are not severe enough, certainly, that one would be a potential death occurring or severe health consequences. Maybe milk as an allergen would be one, certainly. We might see that being the case. In a Class 3 recall, the product is not likely to cause any adverse health consequences. It just may be aesthetically displeasing. And an example of this would be exceeding the defect action levels in terms of the number of insect parts, whole insects, or rodent hair, say, in popcorn would be some examples where that would be a Class 3 recall. Up until passage of the Food Safety Modernization Act, the FDA could not order a recall. With passage of the Food Safety Modernization Act, a major point of the Food Safety Modernization Act related to recalls is now the FDA can actually order the recall of product. Recalls were voluntary until passage of the Food Safety Modernization Act. At that point in time, before that time, the FDA could encourage a recall, but as I said, they could not order a recall. There were no requirements to notify the FDA of a recall. Certainly, it's very desirable to notify the FDA because they certainly have the expertise in how to go about making sure that you do the proper steps in a recall of product. Recalls are the largest category of FDA enforcement action. So of the 4 options they have available, this is the one that is the largest. And by contacting the FDA, could reduce the risk of any legal action by the consumer. So there are reasons why, even though you're not required to notify them of a recall, unless it's one certainly that they order, certainly reasons why you would want to do that. The guidelines for implementing a recall can actually be found in the Code of Federal Regulation. There's a definition of the terms under 21 CFR 7.3, and then the recall policy in 21 CFR 7.4. Voluntary recalls certainly are an option to court action that a company probably would not want to have occur. And the FDA's policy as it relates to recalls is 1, to protect you as the consumer, but 2, it's also to assist the company in making sure that they get that product out of the marketplace before it becomes a serious issue. The important first step in a recall, the major, certainly determining the class of that recall, is the first step that the company needs to do. And as we've already said, the class depends on the degree of hazard or violation. And if you're not sure if you're initiating a recall as a company and you're not sure what class of recall it ought to be, the FDA can be very, very helpful, certainly in making you aware of what the correct determination should be. The strategy for a recall is covered under the Code of Federal Regulation 21 7.42. And that will help you determine the depth of the recall needed. Do you need to recall that product all the way down to the consumer? Or can it be a market withdrawal based on the severity of the product violations? Do you need to warn the public? And certainly we see this again quite often where the public is warned about product that they need to either return to the supermarket or destroy themselves. I think probably one of the biggest ones we've had recently was the one with the romaine lettuce that was contaminated with salmonella, and because they couldn't actually isolate where that salmonella came, or where the romaine lettuce came from, they actually told the consumer not to eat any romaine lettuce and to destroy any romaine lettuce that they had or return to the supermarket. It's the types of checks to measure the effectiveness of the recall are also found in recall strategy. Factors to consider, you need to evaluation of certainly the health hazard. You need to have the ability to identify that product in the marketplace. And with fresh produce, this has been something that's been quite difficult to do. oftentimes they can determine which product in a mixed product, such as seltzer, where we had a major issue certainly several years ago, is to determine which ingredient in that seltzer was responsible for that particular foodborne pathogen. And then consumers' identification of defective product, you need to be able to know lot numbers, certainly, maybe process date that might be on the product that you would use to determine if you have product that is in a recall. And then determining the amount of product that's still actually in the marketplace. Their FDA will request information from you, and they're going to want to know the identity of the product. What is the product? Is it seltzer? Is it romaine lettuce? Is it chili peppers? Some examples. The reason for the recall and the date that the company actually discovered that product would be in violation and might need to be recalled. Evaluation of the risk, where one would determine actually the class of the recall that you've determined, the total amount of suspect product that has been manufactured, where that product has been distributed to, the company's recall communication, the actual recall procedure that the company is going to use, and then name, address, and phone number of the company. Once you've notified the FDA, they will review the information that you have submitted to them, and they will make recommendations. And this notification will be published weekly in the enforcement report, so you can go every week. You can actually subscribe to the weekly enforcement report, where you will get a report of product that's been recalled on a weekly basis. The FDA today, you can go on and actually register and have them send you them on a daily basis. And they will remain closely involved until a recall is completed satisfactorily. What happens in the termination of a recall? This is when the FDA determines that the company has made all reasonable effort to remove that product from the marketplace. When the product is removed to a level commensurate with the degree of risk. So certainly if it's a product where we're extremely worried about potential death for some consumers, we want to make sure that we get that product, as much of that product certainly, out of the marketplace as possible. In the case of market withdrawal, we don't need to worry about going down to the consumer level. Then the FDA actually does issue a written notification of termination of a recall. Some general industry guidance in terms of recalls. The industry or a company, manufacturer, should have a written plan, and it needs to be rehearsed so that you know you can remove that product. You need to have product code system that will facilitate removal of product, certainly. And then you need to maintain extremely good records of product distribution so that you know where any product that's in violation has been sent to. The assignment for one of the assignments for this week is to go to the FDA website and find recent examples of a Class 1, 2, and 3 recalls of a food product. A couple websites where you can find this, or you can actually just go to the FDA website, fda.gov, and you'll be able to find and Google for, search for types of recalls. A couple examples, January 23rd of this year, General Mills in Minneapolis, Minnesota, actually recalled unbleached flour, and the reason for this was this product was potentially contaminated with salmonella. Now the things when you get into one of these, it's interesting, is if you keep following these, if somebody, another company has purchased some of this flour and used that flour in products that they're making, then they oftentimes certainly would be instituting a recall because they've used this product as an ingredient in product that they're manufacturing. And this happens quite often with these types of products. On December 11th of 2018, another Class 1 recall, Del Monte Foods Incorporated. They had a product, canned Fiesta corn seasoned with red and green peppers. And the reason for this Class 1 recall is the product was an underprocessed low-acid canned food. And again, one has to worry certainly about the formation of botulinal toxin in this type of product. And botulinum toxin certainly can have a fairly high mortality rate. So this institutes a Class 1 recall for this product. Class 2 recall in February of this year, Taylor Farms in Texas. Their product was chicken products, and the reason for their recall was undeclared wheat. And again, wheat allergens typically are not going to be so severe that it's going to lead to unreversible complications or death with a consumer. But certainly individuals can have reactions to undeclared wheat in a product. And as a Class 3 recall in January of this year, All People's Food of Newcastle, Delaware. Their product was smoked whole chicken, and this product had undeclared monosodium glutamate, or SMG. I know some people think MSG is a food allergen. It is not. It does lead to a food intolerance, but it's not a true allergen. It doesn't elicit IgG response in the immune system. And the food trivia question for this week is, what company developed the lollipop?